We haven't non-suited Mr. Perkins, so technically, right? All right, good afternoon. The court will take up the next case on the court's docket. This is CV 2002066. This is in the interest of Camiga Eve Anita Dominguez, a child. The case is set for a bench trial today on a petition filed by the Department of Family and Protective Services. The hearing today is being conducted pursuant to emergency orders at the Texas Supreme Court via Zoom video conference. Participating in the hearing today on behalf of the department is engaged case manager Stephanie Kirby and Brown County Attorney Shane Britton. The mother of the child is Evan McLean. She has signed a waiver of service citation that's on file with the court on February 13, 2020. The court would take judicial notice of the court's file to the extent it also reflects that she has executed an affidavit of voluntary relinquishment of parental rights to the Texas Department of Family and Protective Services on November 10, 2020. That was filed with the court on that date. Ms. McLean is not present. The court had previously appointed Emily Miller as her attorney ad litem, and Ms. Miller is present. Previously identified in the department's pleadings as an alleged father of the child was Javier Dominguez, who was personally served with citation notice on February 10, 2020. Paternity testing subsequently ruled him out as a father of the child, and he was non-suited and dismissed from his suit on July 16, 2020, and the court will take judicial notice of the documents relating to that matter. The court will take judicial notice that Brady Perkins was identified as a presumptive father of the child, and Mr. Perkins was personally served with citation notice of suit on July 16, 2020. Mr. Perkins, I believe, is currently incarcerated in a Texas Department of Criminal Justice facility, and he is not present. The court would take judicial notice of the court's file to the extent it reflects that Mr. Perkins has not made a request to the court for a court-appointed attorney and no attorney purporting to represent him as entering an appearance in the case. And he filed with the court on July 21st, 2021. He previously filed with the court a pro se response to the action denying that he could be the father of the child. That was filed with the court on July 22nd, 2020. The court would take judicial notice of the court's file to the extent it reflects that the department filed with the court on July 21st, 2021, a DNA test report that, based on the court's review, that report appears to indicate that genetic testing has ruled out Mr. Perkins as a father of the child in this case. And if I didn't note earlier, Mr. Perkins is not present. Also identified in the department's pleadings as a alleged father of the child in this case is Ricardo Gonzalez. The court he was cited by publication through posting on January 26, 2021, based on the court's order for publication through posting entered by the court on July 25, 2021. Mr. Gonzalez is not currently present in the courtroom. The court has appointed for him, based on his citation by publication, Chelsea Timmons as his attorney ad litem to represent him in the case, and Ms. Timmons is present. The attorney and guardian ad litem for the child is Jennifer Broughton, and Ms. Broughton is present in the virtual courtroom. Also participating in the hearing today are Eric Conroy and Charlie Conroy, who are the current caregivers for the child. The court will excuse the child from participating in the trial today. Before we take up the trial, Mr. Britton, as I noted earlier, the court file appears to reflect that attorney testing was conducted on Mr. Perkins, and the results of that testing reflects that Mr. Perkins cannot be a biological father of the child that's the subject of this suit. Is the department making a motion that he be non-suited and dismissed from the case?
That is correct, Your Honor.
Is there any objection to the court non-sitting and dismissing Mr. Perkins from the case based on that attorney test?
No objections.
No objection, Your Honor.
All right, the court will grant that motion, and I'm non-sitting and dismissing Mr. Perkins from the suit based on that testing. That'll leave as the respondent, alleged father Ricardo Gonzalez, being the possible father of the child, according to the department's pleadings. All right. As I noted, we're set for trial. Mr. Britton, is the department ready to proceed?
We're ready, Your Honor.
Ms. Miller, are you ready to proceed?
Yes, Your Honor, I am. Thank you.
And Ms. Timmons, are you ready to proceed?
Ready, Your Honor.
And Ms. Broughton?
Yes, Your Honor.
Okay. Is anybody invoking the rule?
No, Your Honor.
No.
The rule is not invoked. Is there any opening statement from any of the parties?
No.
No, thank you.
All parties are, all counsel are waiving on the opening statement. All right, thank you. All right, I'm going to ask Ms. Kirby and Mr. Conroy and Mrs. Conroy, if each of you could raise your right hand, please. Each of you solemnly swear or affirm any testimony you give today before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Yes, sir.
Thank you. All right,
Yes,
thank
sir.
you. All right, thank y'all. Mr. Britton.
Thank you, Judge. First, the department would ask that you take judicial notice of the entire contents of the court's file.
Any objection to the court taking judicial notice of the contents of the court file?
No objection.
No.
No objection being heard. The court will take judicial notice of the contents of the court file, including all pleadings, orders, affidavits, permanency reports, and other documents and information contained therein.
Thank you, Judge. I'll call Ms. Kirby.
All right, thank you. You can proceed.
Ms. Kirby, you are the permanency case manager for To Engage.
Yes, sir.
The child in this case is placed with the Conroys, is that correct?
That is correct.
Now, the Conroys are actually the placement for siblings of this child, correct?
Yes, sir.
And so it is the plan of the department for the child to remain in this placement and eventually to be adopted by this placement.
Yes, sir.
Do you believe that is in the best interest of the child?
Yes, sir.
Now, Ms. McLean has executed a voluntary relinquishment of her parental rights, is that correct?
That is correct.
And that was a fairly recent development, maybe a month or so ago?
It was November of last year.
Oh, okay. So it's not fairly recent. And so you believe, or do you believe that it would be in the best interest of the child to terminate her mother's parental rights based upon that relinquishment?
Yes, sir.
That's an interesting logo Mr. Conroy's got. I don't know what that means. Maybe I don't. Maybe I don't want to know. Maybe that's snuff. I'm not for sure what that is. No? Oh, okay. I better stay out of that. Miss Kirby, Ricardo Gonzalez, we have had no luck in trying to find him.
That is correct.
Now, Miss, this wasn't a name that we just made up. This was a name that Heaven McLean had given to us and indicated this is who she thought to be the father, correct?
That is correct.
I believe, if I remember right from the very beginning, she said that, that it was not Brady Perkins.
Yes, I believe so.
And so we did the DNA testing just to confirm that belief. Then she had at some point in time, well, I think I believe at the birth had indicated that the child belonged to Mr. Dominguez, but then later admitted that it was not biologically possible to be his.
Yes, sir.
She had not begun a relationship with him until after she had was pregnant.
I believe so, yes.
So the best knowledge that we have is the only person that she has ever really indicated was the father was this Ricardo Dominguez.
Yes, sir.
And
It's
she,
Ricardo Gonzalez.
excuse me?
Sorry. Ricardo Gonzalez.
Oh, yes, Ricardo Gonzalez. Yes, I'm sorry. And so she did not have any locating information for him that we could use to find this gentleman.
No, sir, she didn't.
And so if you could tell us what efforts the department has made to find him.
We did a letter to his last known address that was given to us. We used family finders with what information we had. And then we did the service by posting.
Mhm.
I also attempted some jail searches, but there was just too many options. There was no way to verify anything.
Okay. Now, if you would have found him, you would have certainly been more than happy to engage him in services or provide services to him. We just have never been able to find him.
Yes, sir.
Do you believe that it would be in the child's best interest to terminate who we presume to be the father, but I shouldn't use the word presumed, who we think to be the father of the child?
Yes, sir.
And so, Judge, I'm going to pass the witness.
All right. Let's see. Ms. Miller.
Thank you, Your Honor. Ms. Kirby, if this termination is granted today, is it your intention to keep the child in the home of Mr. and Ms. Conroy?
Yes, ma'am.
And you understand that that was the mother's wish, that be the case?
Yes, ma'am.
Okay. No further questions, Your Honor.
Thank you. Ms. Timmons, any questions?
Thank you, Your Honor. Ms. Kirby, do you remember at the last court hearing me asking you a few questions about getting together with mom one more time for a last-ditch effort and seeing if she had any more information to share about Mr. Gonzalez?
Yes, ma'am.
Okay. Were you able to do that?
I've spoken with her. She hasn't given any new information on him. He's just kind of just the name. That's all she's gotten for us.
Okay. Thank you. No further questions, Your Honor.
Thank you. Mr. Britton, any additional questions?
No, Your Honor.
Are there any other questions for this witness?
No, Your Honor.
Any other witnesses from the department, Mr. Britton?
No, Your Honor.
Okay, thank you. Ms. Miller, did you have any witnesses you want to call?
No witnesses, Your Honor.
Thank you. And Ms. Timmons?
No, Your Honor.
Thank you. And Ms. Brock?
No witnesses, Your Honor.
Okay, all parties rest in closing.
We do, Your Honor.
Yes,
Thank
Your
you.
Honor.
Any closing arguments or statements of position from the attorneys?
No.
Just as the ad litem judge, I'm definitely in agreement with the termination. I know that the Conroys have been real anxious to be able to do an adoption, and that this is a good placement for this child, and I think it's definitely in the child's best interest to be able to proceed with that.
No, thank you. Anything else? Or anyone for the day?
No.
Yes, Your Honor.
Go ahead.
Thank you. I'd just like to note that, I mean, I did review the return from the posting. It is appropriate, and I believe that the Department in To Engage has exercised due diligence in trying to find Ricardo Gonzalez, and I also had no luck tracking him down.
Thank you for your efforts in this case. If y'all stand by for just a second. All right, the court, pursuant to Chapter 201 of the Texas Family Code, after hearing the evidence presented at trial and after taking this judicial notice of the court's file as noted earlier, and having heard the recommendations of the attorney and guardian ad litem for the child, is going to make the following findings and enter the following orders. The court finds that a request for identification of the court of continuing jurisdiction has been made as required by the Texas Family Code, and no other court has continuing exclusive jurisdiction of the child, and that this court has jurisdiction over this action. The court finds that all parties entitled to notice have been notified. The court finds that the appointment of the respondent mother or the respondent alleged father, Ricardo Gonzalez, as a managing conservator or as a possessory conservator of the child is not in the best interest of the child, because such appointment would significantly impair the physical and emotional development of the child, and that any presumption that they should be appointed as a managing conservator or as a possessory conservator is rebutted. As to the respondent mother, the court finds by clear and convincing evidence that the respondent mother has knowingly and voluntarily executed, after the suit was filed, an affidavit of voluntary relinquishment of parental rights to the Texas Department of Family and Protective Services, relinquishing her parental rights to the child the subject of this suit, which relinquishment was filed with the court on November 10th, 2020, and was executed pursuant to in accordance with Section 161.001B1K and Section 161.103 Texas Family Code. The court further finds by clear and convincing evidence it would be in the best interest of the child for the court to terminate the parental rights of the respondent mother pursuant to those sections and Section 161.001B2 of the Texas Family Code. As to the respondent father, Ricardo Gonzalez, the alleged father, the court finds by clear and convincing evidence that after being served with citation, he has not responded by timely filing an admission of paternity or a counterclaim for paternity under Chapter 160 Texas Family Code within the meaning of Section 161.002B1 of the Texas Family Code. The court further finds by clear and convincing evidence that the child was under 1 year of age at the time the petition for termination of the parent-child relationship was filed, and that the respondent alleged father, Ricardo Gonzalez, is not registered with the paternity registry under Chapter 160 Texas Family Code within the meaning of Section 161.002B3 of the Texas Family Code. And in connection with that finding, the court would find by clear and convincing evidence that the department has filed with the court on February 10th, 2021, a certificate of paternity registry search relating to the child, the subject of this suit. That is dated February 3rd, 2021. That reflects that a search of the paternity registry was made and no notice of intent to claim paternity of this child was filed. The court finds by clear and convincing evidence that it would be in the best interest of the child for the court to terminate any parental rights of Ricardo Gonzalez to the child. The court finds by clear and convincing evidence that the court's findings under Section 161.001B Texas Family Code and the order of termination of the respondent's parental rights is not based on evidence precluded from consideration by the court under Section 161.001C Texas Family Code. The court finds it would not be in the best interest of the child to appoint the respondents, a relative of the child, or any other person as managing conservator. It would be in the best interest of the child to appoint the department as permanent managing conservator of the child and continue the child in the current placement pending further order of the court. It's therefore ordered that the parent-child relationship is terminated between the respondent mother and the child, the any parent-child relationship existing between respondent alleged father Ricardo Gonzalez and the child is terminated. The department is appointed as permanent managing conservator of the child with the rights and duties of a permanent managing conservator under Texas law. The current placement of the child with the Conroys is approved pending further order of the court. The court will continue Jennifer Broughton as attorney and guardian ad litem for the child pending further order of the court, and the court will discharge with the court's thanks Emily Miller and Chelsea Timmons from their appointments 31 days after entry of a final order by the court, reflecting the findings and orders announced by the court today. The court will set a permanency hearing after final order on October 7th, 2021 at 11 a.m. The court gives notice to the parties and counsel the right to appeal the court's findings and orders pursuant to section 263.405 Texas Family Code, and the right to request a de novo hearing before the referring district court pursuant to section 201.015 Texas Family Code. The court gives notice that an appeal in a suit in which termination of the parent-child relationship is sought is governed by the procedures for accelerated appeals in civil cases under the Texas Rules of Appellate Procedure, and that a failure to follow the Texas Rules of Appellate Procedure for accelerated appeals may result in the dismissal of the appeal. The court will enter an order for termination of the parental rights containing the findings and orders of the court upon submission by the department. Ms. Britton, anything else we need to address for the
No, Your Honor.
Ms. Broughton, Ms. Miller, and Ms. Timmons? Anything else?
No, Your Honor.
No, Your Honor.
Miss Conrose, I know it's taken a long time to get here, but I appreciate your patience and everything you've been doing for this child while this case is going forward. I wish you both the best of luck. Thank you. We're adjourned for the day. Thank you.